I bother, there's a pretty good reason for ensuring that we've sort of taken those steps. And certainly if we're going to make a policy we have to be prepared to live by our own rules. So now, without any further ado, I'm going to bring up Allison Taylor to take us through her thoughts about medical notes. And this has been through COVID and after, and well before, a perennial issue. We routinely deal with issues like this in our office, and Allison, I think, has presented 3 or 4 dozen times on this in the last 2 years. So you're in good hands.
Thank you, Jeremy. Can you hear me okay? I'm shorter than Joe. Okay, so I don't think it's a surprise to you in this room. I'm sure the notion that one of the biggest problems that employers have to deal with is absenteeism and potentially accommodation on a return to work after a period of absenteeism or for other kinds of reasons, medically related reasons. And of course, both of these issues are fundamentally based on there being some kind of medical evidence that supports what the employee says about their physical condition, their mental condition, their ability to work with or without accommodation going forward. So that means that the quality of medical documentation is really key to establish what the restrictions and limitations are that affect the employee and whether the employee is acting in good faith. And so the purpose of my presentation today is to try to assist you through that process. Now, I want to, as an aside, from the outset say that I know that employers really hate dealing with medical notes. I got a reaction immediately from the audience. And that's really true because we're worried about having too much information. We don't want to have too much information. We're very conscious of privacy. We really don't want to get into a fisticuffs with the employee over whether they are or are not entitled to be absent from work, if their medical is good enough to support that, if it's good enough to support the accommodation they may want going forward. And we may also like to feel that we like to see the best in human nature. And I'm very cognizant of that as well, that we really don't want to work on the assumption that everybody is lying to us all the time. And all of those are very important factors, and I don't want to minimize them in any way. But, it's a little bit like trusting people too much who call you on the phone and tell you they're calling you from your bank. You kind of have to be a bit defensive. Otherwise, you can get into a mess. And then you realize months and months and months later that you're in a mess, but it's hard to climb back out to get back to where you should have been from the beginning. So the goal of this presentation really is to say we want to deal with medical notes in a way that protects us from bad consequences in the future that could result from our failing to take appropriate steps now. So I want to start off with when not to ask for medical notes. You may have seen the amendment to the Employment Standards Act that indicated that we can't request medical notes for the 3 days per year of ESA unpaid sick leave. Now that we know came about because the doctors who are in a fight with the province anyway over getting paid. I know this because my doctor tells me all the time when I go and see him about anything. They're in a constant battle about this. Nobody wants to pay the doctors to do sick notes. That's the same in all of the provinces. And of course, sick notes are more and more and more important because with the explosion in mental health claims over the last 20 years, say, doctors are being asked for notes constantly and nobody wants to pay for them. The employee doesn't want to pay. The employer doesn't really want to pay. The state doesn't want to pay. Ergo, there's a problem. Now, unfortunately, when I went back and looked at how this was announced, the press, of course, as they usually do in these situations, kind of get it wrong. And they talk about the abolition of sick notes. And so anybody just reading the newspaper would figure, well, I guess you can't ask for sick notes anymore. That, of course, isn't right because the article goes on at the very bottom to talk about how it's really talking about ESA sick leave. But, people don't read that far. We know that people have very short attention spans these days. So a lot of people will think that you just can't ask for sick notes. That's not correct. But you may get a fight particularly from, if I may put it this way, it makes me sound so old, but from the younger generation who will get more of their news in these little bits, and won't necessarily ever get to the end of the article, right? So it's important, I think, to be prepared to recognize when you can't ask for those notes, but be prepared to push back against employees who think that this is a wholesale prohibition. The other thing that's important, though, is because you can't ask for sick notes for the 3 days, it means you have to keep good records. So you have to know which 3 days were the 3 days, because if you blend the 3 days with other days, then you've tainted your request for sick notes, which means you're violating the ESA. So that means you need good records, which means if you have a kind of casual policy about how people call in and report that they're going to be sick, well, that's not a good idea, because you've got to keep good records and records of why the person says they're off. If their car is in a ditch, that's not a sick day. That is unfortunate, but it's not a sick day. It doesn't qualify. Make sure you're recording those days properly. Keep in mind as well that if you happen to provide pay for sick days, then the note you're asking for is not for the sick time. It's for the pay. So if the employee says, well, you can't require me to give you a note, that's fine, but I don't have to pay you either, because the pay is in order, the note is in order to get paid. So yes, you can have the time off. I can't do anything about that. But if you want to be paid, you better give me a sick note. So the corollary of when not to ask is when to ask. And I'm going to get into other circumstances where employees can refuse later, but I want to just talk now about when it's appropriate to ask for a sick note. Now, getting a one-line medical note is very common when somebody says, I'm going to be off for a week or 2 weeks with something. Now, we often accept that. We may question why you have to be off for a week or 2 weeks as opposed to 3 days. But nonetheless, a lot of the time it's more trouble than it's worth to ask about. But this is not always a good idea. And a lot of the time it's better to ask questions from the beginning. For example, the employee suddenly is sick when the day before they weren't sick, right? So we're not having an onset of flu going on here. There was no other kind of demonstrated illness or condition before departure. And most particularly, the departure was preceded by a fight in the workplace about something, which is the big cases where those of you in the audience will normally call one of us because something has happened and now the employee is off sick. So, employee gets denied vacation for a period of time and then takes the vacation period anyway by saying they're sick. My personal favorite. An employee has a poor review. There's an altercation in the workplace. Suddenly the employee is sick the next day. And it's ubiquitous that employees and doctors, for that matter, seem to think that there's something called stress leave out there, which means that anytime any decision is made or discussion is held the employee doesn't like, they can just go off sick. That is not the case. That is not the case. And if you do it, and then later on, this sick leave of 2 weeks, because 4 weeks, 6 weeks, 8 weeks, 3 months, which is kind of a pattern we often see, you will then get criticized if you start asking for notes at the 3-month point and not at the 2-week point where you already knew there was an issue. And the Human Rights Tribunal, for example, has made comments about how long it takes people to ask for sick notes. So an example is the Knight and Surrey Place Center case. The employer took 2 months to get proper medical documentation. And unfortunately, the employer had an insurer that was involved in this process. The employer took a month before it referred the case to the insurance company. Then the insurance company took some weeks before it got around to making the inquiry. And when the insurance company finally got around to making the inquiry, it asked for medical records going back 6 months, even though the nature of the condition was an onset of right now. Then when the medical came in, there were issues. The insurer did not ask for clarification. The employer did not have access to all of the information because it had farmed out this process to the insurer. And the net result was that the employee won on the basis of procedural breaches to the Human Rights Code. In other words, that the employee had the right, ironically enough, to have the medical asked for and adjudicated early in the process. So the fact that there was all this delay, which might look just kind of like when we're not too worried about this situation, came back to bite the employer in a major way. The insurance company also, a lot of the time we like to farm these processes out to the insurer, right? And we love that because it means, well, I don't have to hear anything about medical. I get the insurance company to do that instead. Well, unfortunately, the insurance company is your agent. So to the extent that the insurance company receives information and then fouls it up in terms of the delay process, you wear that because they're your agent. You're hiring them effectively. Their faults are your faults. So what that means is that although you think that you're pushing all this liability out onto a third party, you're not. Ironically enough, the underlying issue had to do with working from home, about which I'm going to talk more today. And there were no supporting restrictions and limitations for working from home anyway. So if it hadn't been for the delay in this employer getting on with asking for the medical, referring to the insurance company promptly, getting the insurance company to act promptly, get the information, not get too much information, and so on, the employer might have won this case. Instead, it lost on procedural grounds. So this is a word to the wise that you're not doing yourself or in any kind of favor in delaying asking for medical documentation in a situation like this where you've got a bold request, for example, to work from home. Now, as I said, you cannot rely on a third party as a way of avoiding liability. So if you use a third-party adjudicator, it's true you don't get the medical, which is unfortunate because now you can't evaluate it for yourself. But if they're wrong, you're wrong. And, you've got to also remember that these adjudicators are in a business to make money. So the question is, how much attention are they paying to medical documentation for short-term leaves? And the answer is not much. You'll get a lot more attention from an insurance company once it's paying LTD out of its own pocket, right? Then it has skin in the game. But for short-term leaves, the people who care about this are you. They don't particularly. So you're not doing yourself any favor by farming out this review of medical simply so that you don't have any information yourself, and yet you're going to wear the liability in the end. Keep in mind as well, like I said, that there's a difference between being qualified for money and being qualified for time off. An employer always has a fundamental right to know why an employee cannot work for it. The fact that it may provide income support mechanisms of various kinds does not mean that the employee does not have to justify where they are. And I would really urge you not to just rely on an insurer for this or an adjudicator for this. You should get your own medical from the employee's doctor that explains why this person cannot work. Because it's only in that way that you have enough information to make decisions. And the decisions ultimately are your decisions. Now, as I say, people don't like this because they don't, I've had many conversations with employers where I've said, that, you should do this. And they say, oh, no, we don't want any medical. We don't want any medical. We don't want to know. But, there are unpleasant things in life, and dealing with medical notes is just one of them. It's like going to the dentist. Nobody likes to go, but nonetheless, you have to do it because you want to be in a position to defend yourself later on if you need to. And if you have not enough information, it's your own liability. It's your own fault if you don't ask for information. Typically what happens is people like privacy until they stop liking it. It's 6 months later, you don't know where this person is, you're frustrated and angry, and then all of a sudden you want to do something dramatic. You want to get rid of this employee. But if you haven't asked from the beginning because of a fear of privacy, then you're in trouble because you can't suddenly change your mind about caring about privacy in that way. So don't rely solely on an insurer, adjudicator, whatever. Get your own medical. And particularly if you're dealing with somebody who had an altercation of some kind with you and then stormed out and hasn't come back since. As I said, when an insurer deals with return to work issues, just like LTD, it's doing so in its interests a lot of the time. It wants to stop paying LTD benefits, understandably, but its desire, its own interests are driving what it does. It's not concerned with your liability. It's concerned with its paying money. It may pressure an employee, for example, to return to work without proper accommodation. If you go along with that, then you're wearing the result, which is a failure to accommodate. It also, the insurance company has less information about the workplace than you do. So it's not really in a position to be able to talk about accommodation. That's a conversation between an employee and an employer. Insurance company is an insurance company. And to the extent that it has a return to work program and so on, you should think of that as really protecting it rather than you. Accommodation is a multi-party collaboration between stakeholders, employer-led, employee, doctor, insurer, union. There are lots of parties, but in the end, the responsibility is the employers. You can't farm that out, so it's just as well not to try from the outset. So how do we ask for better medical? We have this terrible one-line note, the employee's been gone a month, and we don't know what to do. Well, sometimes we just say to the employee, you know what, we need better medical. And if you're like me, you may have had some cases where the employee says, tell me what to say. You should never tell them what to say. Because in the end, they just want you to tell them what the right answer is to get what they want. And that's not what medicals are about. So you don't say, don't ask for better medical. Don't engage in what medical ought to look like. Instead, you want to give them a letter, because for the exact reason that Jeff was talking about earlier, lots and lots of lovely letters are great defense for an employer, always. Provide a letter to the employee outlining what your reasons are for the request, with a consent for the doctor and a letter to the doctor. You may want to wait until the first period of absence is up, which might be a 2-week absence, say. But if somebody walks out after having an altercation, I might ask for better medical the minute the medical comes in the door. Because what's the point in waiting? You already are suspicious about the bona fides of the medical. So why wait? The letter to the doctor will ask for the general nature of the medical condition, but not diagnosis. We'll come back to that. Restrictions and limitations experienced by the employee due to the condition. Very important. Having a disability does not mean you're disabled from working. Similar word, obviously, different meanings. Whether the restrictions or limitations can be accommodated in the workplace, if so, how? If not, why not? Job description is helpful because, as I said, employers often don't know what the employee does. They certainly know nothing other than what the employee tells them. And then prognosis. Now, you do always have to ask for consent. I don't want to overly emphasize this whole non-privacy thing by suggesting that you can get medical without consent. Written consent is always required. In Ontario, we don't have privacy legislation the way some of the other provinces do. Common law principles, though, apply. Medical documentation is always confidential, and consent to disclosure is required. However, in the end, an employee provides consent or they don't get what they're asking for. And we'll come back to that later. And in provinces with privacy legislation, there is a mechanism by which you can do the same thing, but you effectively have to say to the employee from the outset that you will be requiring documentation on a go-forward basis during employment for various employment-related purposes. Otherwise, you have to ask for the employee's consent every single time that you do it. In other words, this is a higher standard that you have to enter into by contract. So let's just talk about restrictions and limitations. The main goal of writing this letter to the doctor is to figure out what the employee can and cannot do, what their restrictions and limitations are, and also what they say about accommodation. Because firstly, if the person is off altogether, you want to know why. And secondly, you want to know whether you can craft something based on those restrictions and limitations, which will allow the employee to come back to work. And there's no question under human rights law that restrictions and limitations are an entitlement of an employer because they're necessary to craft accommodation. Now, a lot of the time we get pushback from unions and from employee counsel who will say, you don't need this information because the employee isn't asking for accommodation. They want to be off work. And this always drives me crazy because my view, and I think this is supported by human rights law, is that a leave of absence is an accommodation of sorts. And the explanation in this case, Scarlett and Hamilton Health Sciences Corporation, is that effectively a leave of absence is the only way for the employee to heal enough to be able to think about coming back to work, right? The goal always being to get back to work. And I think it's important also to focus on the fact that the employee's right is to work, right? Accommodation law is all about accommodating people so that they can work, not so that they can't work. So the focus is on the ability to work. Accommodation is to allow an employee to be able to work. A leave of absence is to allow an employee to heal enough to be able to work. So that's fundamentally what we're looking at. And unless you have the restrictions and limitations of the employee, you cannot judge whether the absence is bona fide, and you cannot judge whether you can accommodate the employee so that they can work. And again, income supports are not the point here. The employee has the right to work and to be gainfully employed. That's the whole point of accommodation law. So the employer needs the restrictions and limitations to determine whether there's an alternative to a leave of absence and whether the leave of absence is validated. Now, unfortunately, sometimes with employees who are troublesome, an employer will say, well, let's just let them be on a leave of absence because they're out of our hair for a while. I know that's very tempting because I've seen it happen over and over again. It's a bad idea. And again, I liken this to going to the dentist. Sometimes you just have to do unpleasant things. And dealing with this kind of situation is an unpleasant thing. So even if their disability benefits are available, even if they get on EI, which frankly a monkey could file for EI sick benefits and get on sick benefits, right? It's easy peasy. Even if that's the case, you still want to be going through this process because again, it's harder to do it later if you haven't done it earlier. So you want to start from the beginning. Now, employees, of course, don't like this, because their goal in going off, and keep in mind when I say employees, I'm not talking about the ones who just had gallbladder surgery and are genuinely laid up and can't work. I'm talking about the ones who are a thorn in your side because you know there's something wrong with this picture. Okay? So employees don't want you to ask for restrictions and limitations because there really aren't any half the time. They just want you to let them be off work. Now, the Ontario Human Rights Commission policy on ableism and discrimination is very clear that accommodation seekers, which I would take to include people who are off work, can generally be expected to provide to support accommodation includes that the person has a disability, and then the limitations or needs associated with the disability. So there's a clear distinction between having a disability and having needs that require accommodation in the workplace, including time off work. So it's documented in that documentation, and you should not be afraid to say so when you're dealing with a situation of this nature where an employee says you're not entitled to this information. Now, I do want to emphasize the issue about privacy, because as I said from the beginning, employers are very keen on privacy. They don't want to step on the toes of other employees. They wouldn't want it done to them, and I understand all of that. But the law is perfectly clear that if you want any kind of accommodation from the normal rule that you come to work and I pay you, so including absence from work, the employee must sacrifice some privacy. That's the trade-off. Otherwise, they have to follow the rules. They're absent from work, they're abandoning their job, they get terminated. It's very simple. So it's not the law that an employee can hand you a one-line note and then be off for months and months and months, and you can't say anything or do anything about it. Although I get lots of pushback from doctors insisting that that is in fact the law. It's not. So the law actually, as I told you in the case that I mentioned earlier in Wright, I think it was, the law encourages questions as long as they're the right questions. Right? As long as they're related to restrictions and limitations and trying to get someone back to work, which is their right, that is what we're talking about here, then you're allowed to ask questions as long as they're judicially and appropriately worded. And you can even ask more questions about the nature of the disability if you need to know in order to understand what the restrictions and limitations mean. Or think of it this way, if the employee has already told you, I have depression, where's the privacy issue? They just told you that they had depression. So you can then say, well, the employee has reported to me that they have depression. Can you validate that? Because it may affect how you interpret the restrictions and limitations. So we shouldn't be slavish about the idea of privacy and say we can never ask any questions at all of an employee. That's not, in fact, the case. And if the employee will not waive privacy, and you do sometimes get people who are internet educated on this subject, and they say, no, medical information is private. I don't have to give you anything. then the response is, well, that's fine. I don't have to give you a leave of absence accommodation either. Your choice. You have to waive some privacy in order to show that you are entitled to the accommodation that you're seeking. If you don't want to do that, that's okay. And courts like in Batilia and Ottawa Catholic School Board have said Section 17(2) of the Human Rights Code establishes the right of an employer to seek appropriate medical up to and including an independent medical examination. And that section says no court, tribunal, or court shall find a person incapable unless it is satisfied that the needs of the person cannot be accommodated without undue hardship. Well, in order to understand whether you can accommodate to the point of undue hardship, you need information. So accommodation law is all about information. That's why it's a collegial sharing of information type of situation between the employer, the employee, their doctor, the union, and so on. So the employer has a right and arguably, as this case says, an obligation to obtain sufficient medical information to know whether the employee can perform the essential duties or not. And the importance of this, I think, is clear by virtue of the reverse, if you like, which is if the employer assumes from the medical condition that the restrictions and limitations are more disabling than they actually are, that is clear discrimination. That's like advising that a person of a particular height or weight can't possibly be a firefighter. You know, this is kind of fundamental law. So you can't operate on guesswork to understand the restrictions and limitations applicable to an employee. You're supposed to be basing this on true information about the actual employee, not on stereotypes, guessing, that kind of thing. So in Matthews and Chrysler, the tribunal made the case that there's a failure to accommodate if you don't ask questions and then assume the person is more disabled than they actually are. Now, as I said, employees often talk about privacy as a reason why they don't have to provide more than a one-line note, normally because they're hiding something, because otherwise, why not just give the information? And as I said, the response is this human rights policy provides for restrictions and limitations. We're entitled to validate your leave. If you won't give it to us, then we don't have to give you the leave and we don't have to provide accommodation. And I don't think it's a bad idea, if the context is that the person stormed out after a meeting about something or other, to say, you know, you've brought us into some concern by your behavior about the bona fides of the leave, which is why we're asking the questions. In other words, if the situation is clear cut, there were witnesses to that event. In other words, it's not a he said, she said. There are witnesses to that event. That's the context. It's quite legitimate to raise the context as a reason why privacy does not supersede the right to information. Give the employee the law and the information so that they can comply with your requests. If they continue to refuse to comply, send another letter. Because as I said, lots and lots of lovely letters is what we want in order to be able to defend ourselves if we have to go to the Human Rights Tribunal. There are many cases in the Human Rights Tribunal where an employee was terminated for abandonment. The employee says, I didn't have to give them any medical, this is privacy. The employer says, I said 14 letters and they didn't reply to me any time at all. And the tribunal is not, notwithstanding, concerns about the tribunal being too employee friendly. There are lots and lots of cases where the tribunal says, employee, you just don't get the law. The law isn't what you think it is. The law is you have to give this information when you're asked for it. You don't have an absolute right to privacy, so you lose the case. So I want to be encouraging about this because I don't want you to feel that you're doomed to fail if you go to the Human Rights Tribunal because the employee is always right. That's just not the case. Now, as I said, the employee may be justified in some cases in refusing medical. The 3 unpaid days we talked about, if the illness is very short term, if the employee was obviously sick before they left, employee is justified to say, maybe you're starting to harass me. If you make the same request for information over and over again, then maybe you're engaging in harassment. This is one reason why people say, can you give me a standard letter to use in this situation? I always balk, and I'm sure my colleagues do as well. There's really no such thing as standard because if you have a protocol that says we send this letter, then we send this letter, then we send this letter with this amount of time in between, you're not thinking about the particular context of this employee. You're just following this pattern, whether or not the facts of this case fit properly into it. And that's why you have to really turn your mind on all occasions to what you're doing, because otherwise, if you follow this kind of standard protocol without listening to what you're getting from the employee, then you may be viewed as just harassing the employee by asking for the same thing over and over again and not reading what they send you. So it's very important to pay attention to what you actually get back and make sure that you're dealing with it in a proper way, in a timely way at the time you receive information before you ask for other information. But an employee cannot refuse because they're not seeking accommodation, as we said. They can't refuse because there are no disability benefits at stake anyway. In other words, it's only my presence you're complaining about, you're not paying me. They can't refuse just because they're on EI or STD or LTD, because that's not between you and them, right? That's between them and some third-party agency. And they can't refuse just because they gave detailed medical previously, subject to the harassment comment I made earlier, because things change over time. So if somebody gave you a note 6 months ago, they can't say, well, that should be good enough, because, short of a lifelong disability that's going to be in a steady state forever, things change in life. So one medical at one time is not a get out of jail free card. Now, if the employee improperly refuses to provide medical, it may be appropriate to terminate them for abandonment, for insubordination, in other words, for cause at some point. The more letters you send out that go unanswered, the stronger your case is going to be. Letters, letters, letters. Great. As long as as I said, that you've thought about the content of the letter, that it's not just being churned out in an automatic way. Also, make sure that you've expressed a genuine interest in accommodating the employee in the workplace, because that's what this is all about, getting the employee back to work and accommodating them in the workplace. So if the employee then just ghosts you, they disappear, make every effort to figure out where they are if you can. Can you tell where they are emailing you from? Do you want to put them under surveillance? If you put them under surveillance, you may discover that they're going to work every day for somebody else. I did have that happen once, where an employee was off on sick leave and was going every day to an auto body shop to work on in his friend's business, and he got fired, not surprisingly. So, surveillance may be a tool. Make sure you can prove that your letters have been delivered. I have had a case, in fact, I have an ongoing case where the delivery of the letters is an issue. Even though there's a doorman in the building, there's an allegation that the letters weren't delivered, et cetera, et cetera. So make sure that you send letters in a form that you can track. Make sure you keep all of the records to show that the letters were delivered, because this may come up in a lawsuit. And if you can't find this documentation, then it's gone. So this sort of thing should be in your file. Now, employers often say, is this frustration of contract? This employee's been gone for 6 months. Is it frustration of contract? And they want to terminate for frustration. And I get this question a lot. And I grant that you are experiencing frustration, but it's not the right kind, if I can put it that way. You want to rip your hair out and are gnashing your teeth, but you don't have frustration of contract. Frustration of contract is a very specific thing. It means that you have medical evidence that the employee is permanently unable to return to work due to total disability, which cannot be accommodated in the workplace. That's what it means. And even if the employee tells you that that's the case, beware. I had a case once where the employee insisted they couldn't do that. They were terminated, their ESA was paid out. Lo and behold, we get a letter from a lawyer demanding a common law severance package after the ESA had been paid out. And so we said, oops, sorry, we didn't realize that. Pay the money back and we'll reinstate him and let's start over again. Because, of course, the lawyer is in there as a bit of a barracuda, wanting to go and get a big severance package for this employee who asked to be terminated for frustration of contract, right? Lawyer gets their cut, employee gets a lot more money, and it doesn't bother anybody that the employee started this whole process by basically lying to the employer. So that case kind of went away quietly after that. In any event, unless the person is in a coma, And and even then, the medical evidence would have to still be that this person is going to wake up. You cannot assume from somebody being off for a lengthy period of time that that means there's a frustration of contract, no matter how frustrated you feel. Instead, what you have to do is you have to manage the medical documentation and request it in a clear manner. Now, what if your restrictions and limitations aren't clear? This is an actual case here where the employee in this case was trying to avoid a settlement before the Human Rights Tribunal. It said, the medical said the person had a situational anxiety and PTSD flashbacks, but it also said that their thinking was linear and goal-directed. Well, the tribunal had no difficulty in saying, we're not going to set aside this settlement because this is not an inherently contradictory medical documentation. Your thinking was linear and goal-directed. So sorry, but no. The restrictions, in other words, may seem internally contradictory, but if you can read them in a harmonious way, you should do that. Now, when you get a medical that has that kind of apparent contradiction, you have a couple of options. You could treat it as ambiguous and go back to the doctor and ask for more information, but you give the doctor another kick at the can, right? It may strengthen the case. So you really only want to do that if it really is ambiguous. If it's not ambiguous, you can write to the employee at that point and say, as happened in this case before the tribunal, since you're not stated to be unable to return to work, your sick leave is denied, and we can accommodate your restrictions and limitations in some way. So generally, that is the process I would recommend. So if you have medical that says things like the employee is experiencing challenges, or would benefit from something, or I recommend something, keep in mind that if the employee is not said to be unable to work, then they're not unable to work on the face of the medical. And if they have stress or something else, which is normally the reason for leaving the situation, that can be dealt with through other kinds of accommodations. Do you move the workstation into a less busy area? Do you use noise canceling headphones because the stress of sound is overwhelming? Do you change hours of work? There are other possible accommodations other than just staying off work. Independent medical examinations. Sometimes the medical you'll get from the doctor will just be incoherent. One day they say this, the next day they say that. They go back and forth. It's clearly a strategic game. Where this happens, it may be appropriate to ask for an independent medical examination. They're expensive, but as you saw from what we said earlier, the Human Rights Tribunal recognizes that sometimes that has to be done, and they are not prohibited, and you are permitted to do that in the appropriate circumstances. Medical updates. Again, one size does not fit all. Just because the restrictions and limitations have been provided once does not mean that the same restrictions and limitations will apply for all time. It's not unlike other accommodations for, say, family status. Children grow up, right? Physical disabilities change over time. There's no reason to assume that this is a one-time thing. Don't be afraid to seek updated medical, but make sure you are being reasonable, that what you're asking for is coherent, that you're being even-handed, and particularly that you're not discriminating against mental disability relative to physical disability, which is an important area. Malingerers. Again, this is a situation in which you do want to push for restrictions and limitations because a lot of the time there's something else going on behind the scenes, which is causing the employee to be a malingerer, something else going on in their life. So, for example, and keep in mind that doctors are very busy and they don't have time to deal with all the things going on in their life, in the employee's life. But you may know that the employee has other problems in their life. They may have a sick parent. They may have gone through a divorce and be dealing with childcare all by themselves. They may have other kinds of issues that may really be behind the reason they're not working. That's why it's useful to know your employee well enough to know whether you should be trying to suggest some form of accommodation which accommodates the real underlying problem, as opposed to just granting time off work. Time off work does nothing really for anybody, including the employee half the time. So be familiar with what's going on in the employee's life in order to try to be proactive about what they really need, not what they think they need. Frustration of contract, I want to come back to, because as I say, it's a real thing. If you have the medical documentation in hand, then you can pay out in accordance with the Employment Standards Act only, and you don't have to pay common law. That's a lot cheaper, and it's an advantageous way of doing it. As I said, though, you need the medical. You need the medical to be unequivocal, because if the doctor equivocates at all, if they're kind of, well, maybe next year, you're not going to have frustration. And if you go to court on that case, you'll lose every time, because the court will look at the medical and say, well, the doctor didn't say it was permanent, so it's not permanent. People may be on the verge of returning to work at any time. So you have to be careful of that. But don't wait too long, because, as happened recently, I had a case where somebody was terminating after an employee had been gone for 10 years. And of course, that means 10 more years of ESA entitlements had built up over that time. So that's too long, clearly. Normally, we wait until we're into own occupation if you have LTD, into any occupation if you have LTD benefits, before we think about frustration of contract. Medical notes on returning to work. When an employee is ready to return, you're entitled to a medical note on that occasion to stipulate restrictions and limitations in order to ensure that the return to work is safe. Don't provide informal accommodation ever, ever, ever. Under AOTA, it's now expected that non-occupational return to work plans be in writing, just like WSIB. Return to work plans have always had to be in writing. And, if you have an informal agreement between an employee and a supervisor, how do you prove what the content was? You can't. So accommodation must always be in writing and documented so that it survives turnover of staff. Medical notes for accommodation. Again, you're entitled to restrictions and limitations. Keep in mind that employees, and this brings us back to work from home, often confuse restrictions and limitations with the desired accommodation. So in the Wright case I mentioned earlier, work from home was provided as a restriction. And the tribunal in that case said, that's not a restriction, that's a solution. That's an accommodation. What's the restriction or limitation of the employee that necessitates an accommodation of working from home? That's the question you need to ask. And there's a lot of this kind of blurring of what the employee wants as though it's a restriction when it's a solution. So be cautious about that. Restrictions and limitations have to be caused by the disability and must cause the need for accommodation. So you can have a disability that causes no restrictions and limitations. So it doesn't matter, as rightly it shouldn't. Or you can have one that causes restrictions and limitations, and that causes a need for accommodation, and here are the accommodations. So that chain has to be intact before you get anywhere near accommodation. So working from home is typical. I can't drive, I can't do this, I can't do that. Everybody and their uncle wants to work from home these days. We're not required to provide that automatically on say-so. An employee does not have a right to any or their chosen accommodation just because they have a disability. It has to have an effect in terms of restrictions and limitations. They're also entitled to reasonable accommodation only, not what they ask for, but what's reasonable. So if you can accommodate their restrictions and limitations in 4 different ways, and one of them is better for the business, it's okay to offer the one that's better for the business. That's entirely permissible, and that will be defensible. Keep in mind, there are some times when an employee can't ask for accommodation. They may have a mental illness, they may have alcoholism. In the end, the employee has to provide documentation in support, ultimately, of what you think may be going on, but you're entitled to be proactive and say, we believe you have a mental illness, we believe you have an alcohol problem, this is what we require. Otherwise, we will have to treat this as just misbehavior on your part with attendant consequences. Keep in mind as well, restrictions and limitations are not to be manufactured. That's why you shouldn't suggest answers. They're supposed to be factual, and they're supposed to be the ones actually experienced by the employee. Not what people with that condition might experience, but what the actual employee is experiencing. So read the medical carefully. Remember that accommodation is required to allow the employee to perform the essential duties of the job. If nothing you can do allows the employee to perform the essential duties, you don't have to accommodate them. And if they can only do half the job and someone else has to do the other half, the law doesn't support that accommodation is required in those circumstances. Keep in mind, lastly, cognition problems. Everybody wants to have cognition problems so they can work from home. However, if you've got cognition problems, what's to say that you can work at all, right? You don't have better cognition because you're in your living room. So if you have cognition problems, the first question is, how can I tell that you're competent to work at all? And so again, that should be the source of additional questions with respect to how we measure cognition. And in fact, I had a recent case where all the difficult duties were taken away and the employee was left with answering the phone. And the question is, can you really argue that a cognition problem prevents anybody from answering a telephone? Probably not. In other words, and again, is the employee unable to perform their duties, not whether it would be better for them not to? Again, doctors should not be advocates. Doctors are doctors. And I think I'm wildly over my time here, so I'm going to skip through my slides. So if your restrictions and limitations in successive documentation are counterintuitive, don't be afraid to ask questions. If somebody goes back and forth between better and worse and better and worse and better and worse, then you have to start wondering whether there's something unusual going on. In other words, is this being driven by employee needs? That may be a time to start considering an independent medical examination. It's certainly a time to consider asking some additional questions. I'd love to read you this long quote by arbitrator Serdiovsky because I love it so much. But I'm just going to say, in the ideal world, doctors would have perfect knowledge, but that is not the real world as I know it. So the doctors are not perfect. Doctors are not advocates. Just because you get a note from a doctor does not end the inquiry. With respect to mental illnesses, I just want to caution you against forgetting the fact that many, many mental illnesses, particularly ones that have been added to the litany of mental illnesses over the last few years, can involve manipulation and sociopathic behavior. In other words, that people lie. Rather like alcoholics will tend to lie to cover up their alcoholism, can be the same kind of problem. So it's a fine line to tread to understanding whether what you're getting is truth or what you're getting is part of the etiology of the medical condition. Again, difficult questions to ask. That does not mean you shouldn't ask them. Managing privacy, finally, last topic. Even though somebody does not have an absolute right to privacy, their medical documentation does, if I can put it that way. It's got to be segregated from the normal employee file, access only to those who need to have it. There should be, in other words, a disability file under lock and key, only accessible to those who have a need and right to have all of that documentation. Other levels of employees may need restrictions and limitations, but they don't need to have entire access. And avoid talking about, having loose lips talking about medical conditions. I'm sure this really goes without saying to this group, but you've got to caution managers against gossiping about employee medical conditions and accommodations that do not need to be known, because that will frequently come up in the context of a hostile workplace, that there's a lot of gossip going on and that confidentiality isn't being respected. Thank you very, very much for your attention.